Discussing with Rick Alembic, the Home Affordable Modification Program. And Rick, before the break, we were talking about some of the criteria to qualify for this program. And let's finish discussing those. Not just anybody can apply. You got to show some kind of, I guess, financial hardship. What does that mean?
Well, what it means is you need to document the reason why you can no longer pay your mortgage. And more often than not, it's loss of employment, or employment is regained but at a lower rate of income. Just generally, there's got to be a reason for why you can't afford to pay your loan anymore.
Okay. And the TARP funds are limited, and this is part of the TARP program. How long is this program, the HAMP aspect of it, how long is it in existence?
The program is supposed to sunset at the end of 2012. What that means is that there may still be plenty of money left over that Congress has allocated, but it won't necessarily be able to be used for this program.
Unless they extend it, of course.
Unless they extend it. My hope is that Congress will modify the program and try to do something different, something more practical.
Okay, and I believe you can only do this one time, correct?
Technically, you can only modify your loan once. That's
okay.
Correct.
Now, let's talk about reality. You mentioned a while back that the program. I guess it was sort of a difference between reality and what's happening on the street, and what the law says is supposed to do. So tell me about that.
It's difficult. There's Congress had the best of intentions, I think, but those intentions have not been realized. As I alluded to earlier, Fannie Mae and Freddie Mac have not been aggressive in regulating the program. The program requires the servicers to have a good procedure for identifying potentially qualifying borrowers who could qualify for HAMP, processing their documentation, keeping them apprised of the process of the modification, which is basically a review of their income, a review of the value of their home, and sort of just crunching the numbers to see if the loan would qualify for modification. What's actually happening, though, is that the servicers are, and I deal with many clients almost every day who have these issues. They get in the middle of the program, the servicers will lose their documentation, they'll ask them to resend the documentation, the lenders never speak with the same person twice. They speak with somebody on the phone who is not familiar with their file and asks them to send more information, which has already been sent several times.
How long was this program supposed to take, I guess, from the moment that somebody applies to it and the moment that he's been told? Was there some kind of feel for this sort of be taken care of in 30 days?
The original approach has been that they would put the borrower on sort of a temporary payment plan. They would pay a reduced amount from the original mortgage, and that would often be, the idea was it would last for 4 months or 5 months, 6 months, and that would be called the trial period.
Okay.
And during that trial period, a lot of these borrowers, a lot of my clients included, were assured that, well, if you keep paying this modified plan, instead of saying $1,200 a month for your mortgage, you pay $900 a month your mortgage. If you pay $900 a month religiously for 5-6 months, then they're not exactly promising a result, but they're insinuating that they would be accepted and the modification would go forward.
So was that almost like a probationary period?
Almost like being on
probation? Or it was just to allow you some immediate relief while they process your request?
Exactly. It was kind of a combination of, we will test you to see if you can pay your mortgage on time while we process your request.
Okay. So what is the reality then?
The reality has been that some of these trial programs have lasted a lot longer, sometimes 12, 14 months, a year and a half. And during that time, what happens is the original mortgage, whereas you may have been required to pay $1,200 a month, the homeowner is not paying $1,200, they're paying $300 less. So after a year of being on the modified plan, they're $300 times 12, $3,600 behind on their mortgage. And what I'm seeing quite a bit of, a lot of my clients are being told, well, we've decided that you don't qualify for the HAMP program, and by the way, you're $3,600 in arrear. Because of that, we're going to foreclose on you in 30 days.
So not only do they deny you, but they put you in a position where they force you into foreclosure.
They basically lead you sort of down the path of thinking you're going to have a modification, and you just end up against a brick wall.
Well, what can the homeowner do in that situation? Is there any relief for the homeowner? He was following the rules? and now he's worse shaped than he was before.
The HAMP regulations make it clear that the lender's supposed to work with the homeowner. It's not supposed to be an adversarial situation. And
I mean, is the lender required to say, okay, we're going to spread that arrearage, the $3,600, maybe over a year, or?
They're not required to do that. It's not an obligation. That's the problem with the law. And so what I have been doing as an attorney is I've been trying to help clients out by arguing that, well, you can't foreclose on my client because you've acted in bad faith, in the sense that my client was assured that their loan would be modified, but then all of a sudden you led them into a deep deficit, you led them into default, and now you're trying to take their home away because they're in default, but you caused the default. Mm-hmm. My argument is that represents bad faith on the part of the lender. And Georgia has a pretty clear rule that says that if you're going to foreclose on a homeowner, you better foreclose in a way that shows good faith. You can't just do bad things. You can't sort of lead them into foreclosure.
Okay. So what can the homeowner do? Because the homeowner is already in a tight financial place. That's the reason he's applying for this modification program. What can he or she do to protect himself, in the event that he's not accepted into this program?
And that's why I'm glad I'm on this program, so I want to get the word out. First of all, if you do start a HAMP probationary period payment, you should make every effort to pay into a bank account, savings account, the difference between your modified mortgage and your actual mortgage. So you have that money just in case you don't get accepted. And I know a lot of people are under economic stress and have difficulty doing that, but in order to give yourself some insurance in case the modification doesn't work, you should have that money in reserve in case you don't get accepted. That's one. The other option you should also carefully consider is pursuing a short sale. If you think you're going to lose your home anyway, you don't think you can keep it, and there's a possibility the modification might not work, then consider putting your home on the market for a price that the lender may accept. If it's a market price, if you can study the other sales in your neighborhood, what we call comparable sales, and you can sell your home for what is a market value, or find a buyer willing to buy the home for market value, even though that market value may not be the same amount as your mortgage, maybe less than your mortgage. You need to be prepared to do that because some of the lenders may be willing to forgive the difference between the sale price and your actual mortgage balance.
That would mean, though, that the homeowner would have to work with the lender on two different programs. One, basically the HAMP program that we're discussing. The other one is accept a short sale. And you still got to provide documentations.
And that is, again, that it becomes sort of a paper monster. The homeowner usually will need either an attorney or a good real estate agent to help come up with a short sale plan. Have the agent find prices that are realistic, a realistic price point, try to find buyers who are willing to buy the home for a good price usually, on the condition, and the contracts have to have a condition that the lender agree to the short sale, because once you go to if you sell the home, the lender can stop the sale if the lender's loan's not paid off.
Well, you mentioned that you got some clients that go into this program and 12 months, 16 months later they find out that they're not eligible. What are some of the reasons that you're seeing why people are not qualified for this program?
Yeah, unfortunately, in my experience, and others may be different, my experience, the servicers and lenders are not really giving good reasons. My clients will ask for reasons. They'll generally say things like, well, your debt-to-income ratio was not sufficient, you couldn't prove your income, we weren't satisfied with your paperwork, it wasn't sufficient. And what I see more often than not is that arises in situations where the homeowner is either self-employed or works on a contract basis and doesn't have a very regular income, like a regular paycheck. So that is a factor right there. If you have self-employment income, you're going to have a little bit of difficulty qualifying for HAMP.
Okay. Well, what else can the homeowner do to protect himself in the event that at the end of this process he's denied and now he's in arrears?
Well, other than obviously consulting with a real estate agent on a short sale, possibly consulting with a good bankruptcy attorney who can identify other sources of debt that might be able to be carved out through bankruptcy. Unsecured debt, we often refer to it as like credit card debt, to allow the homeowner to perhaps get caught up on the mortgage under a Chapter 13 plan in bankruptcy.
Well, is it possible to go through this program while in bankruptcy?
No, you won't. You can't do HAMP in Chapter 13
Okay.
or in bankruptcy.
Or Chapter 7.
Or Chapter 7.
Well, of course, it's liquidation. So the only way to stop a foreclosure in that case is to go into bankruptcy?
You can file for bankruptcy to stop the foreclosure. The problem is, since 2008, the bankruptcy laws have been modified to allow the lenders to basically lift the stay on very short notice. When they lift the stay, what that means is you no longer have the protection of the automatic bankruptcy stay, and really within 30 to 60 days,
you're back where you started.
You're back where you started. So it's a temporary kind of let me catch my breath. But that's why it's important to consult with a bankruptcy attorney early on in the process to see if you might qualify for, say, a Chapter 13 or Chapter 7 that could address a lot of your issues.
And there's some talk also about maybe modifying some of these bankruptcy laws, perhaps brought on by a lot of these problems with the foreclosures.
That's correct. Right now, the bankruptcy laws do not allow for what we call principal reduction or a cram down, depending on who you talk to, of the first mortgage. So if typically someone who lends money secured on property, like a car, if the car loses value, then the lender's security is only worth what the fair market value of the car is.
Right.
On a first mortgage situation, the first mortgage lender never loses that priority, no matter what the value of the home is. And so the law at this point is you can't use bankruptcy court to reduce the principal amount of the loan. It's just not going to happen under Chapter 13.
Right, and banks have been fighting this cram down.
And the banks have enough political pull to probably prevent that from happening.
Right, okay. Well, unfortunately, we're out of time, Rick. I want to thank you for joining us today to explain this home affordable modification program and the problems that we're having with it. We'll be back next Sunday at 10 o'clock in the morning. Until then, y'all behave.
Leyes Cotidianas les llega a ustedes gracias al generoso apoyo financiero de la Fundación de Justicia Civil del Estado de Georgia. Mundo Hispánico, el vocero de la comunidad hispana desde 1979.